Thank you all so much. I appreciate your time and attention.
Chair recognizes Mr. Canales on the bill.
Thank you, Mr. Speaker. Members, I'm on the bill because I will tell you that I don't understand what we're trying to achieve here. What I can tell you is I feel like it creates a can of worms for both sides. If the magistrate finds there's no probable cause, you've ostensibly created a defense for a defendant that's going to follow him all the way through to trial. He's going to argue from the very beginning, and it's going to put the prosecution in a real pickle. Now, you also have the other side, that now the officer who knows that he didn't get it right is going to come back and get a second bite at the apple to try to correct it, which still is tantamount to a defense. We don't do this for a reason. We don't do this because it creates a problem for both sides. I would tell you that I understand what the intention is, and we come here often with very laudable and lofty goals, but I don't think this achieves that. And we haven't been doing this forever, and for a reason. If that magistrate finds that there was no probable cause, you can bet dollars to donuts that's going to be the defense from the beginning. And you can bet dollars to donuts that the police officer is going to try to come back and fix it. What you're doing is you're creating a document that creates problems. And I would tell you, I'm speaking on the bill as somebody who's been doing this for 20 years, telling you this is not the way we've done it because it's not the way we do things. And we may be trying to achieve something here, and I hear a lot that it's about Harris County, but the reality is this, is that this will have profound and far-reaching effects that nobody in this chamber will be able to decipher, not from debate or not from hypotheticals. And I will tell you that I caution you when you make such incredibly drastic changes without knowing the ramifications. I don't know all the ramifications. I can tell you this is making my head spin thinking, what in the world are we doing? And it goes for the defense and it goes for the prosecution. You heard my colleague Ann Johnson say, this is going to really hurt prosecutors. No doubt. This is going to really help defendants. Maybe. This is a solution in search of a problem. And I would tell you that we should very, very approach this with the utmost caution and the utmost respect. This is flipping on its head hundreds of years of criminal jurisprudence, and I caution you.
Ms. Johnson in opposition.
He's absolutely right. He's absolutely right when he said Ann Johnson came up here and told you this is going to hurt prosecutors. It is. It's going to hurt prosecutors. People get arrested, and then we say, and look, Chairman Moody said it as well. He said this is going to balance out on both sides. One side gets 24 hours to get a get-out-of-jail-free card, and the state doesn't. There is a reason we have a statute of limitations for 2 years, 3 years, 5 years, 10 years, unlimited, because evidence is going to change. I have seen it on both sides. You get out on the scene, there's a bar fight, there's two guys with a bloody nose or a busted eye, and you say, what happened? Do you have the surveillance? Does anybody have cell phone? You look for evidence, but the clock says that when you're on that scene and you make that arrest, because we want to remove the people from that situation, that we have 48 hours to get them in front of a judge for PC. PC is probable cause. PC is not the end. PC is the beginning to say to the state, you can keep going. We do not take a case before a jury until we have evidence that we can prove the case by proof beyond a reasonable doubt, which means I'm going to issue grand jury subpoenas for that surveillance. I'm going to issue grand jury subpoenas for the hospital to get the medical. Did you do a toxicology? Can I show what their blood alcohol concentration was at the time? Do I have the evidence to extrapolate that back to be able to show what somebody was like at the time? This does not happen within 24 hours. And who are your magistrates? Your magistrates are your judges, like it or not. And in your counties, your JPs are your magistrates. And your JPs aren't lawyers. They might be real estate agents, they might be anything else. And you are now asking the full weight of a determination of a criminal case to come to somebody who just lost, no offense, their realtor job, to look at whether or not we have PC in a major criminal case that will then follow that case for the rest of time. I am deeply concerned. I get it. I get it. Hey, welcome state, this is a Harris County bill. People mad at Harris County. People like to fight about Harris County. People like to talk about public safety in Harris County, and people like to beat up on the judges in Harris County. Well, let me remind you, politically, you now got Democrats and Republican judges in Harris County. I can play this game too. It's a hard system. It's complicated. It's not fair to beat up on your judges. It hits both ways. It hurts the credibility of the integrity of the system. And I'm just going to ask you, do you really think this? Do you really think this is about keeping people safe? Or is it about collecting data or gotchas or being able to criticize certain judges? The problem is this policy is going to affect each and every one of your magistrates, your JPs, your prosecutors, and you're going to live with the consequences. And I am just going to tell you, as a prosecutor, there is nothing I want like a judicial finding from a judge in the first 24 hours to say, I didn't find that witness credible. Because that's a stain of which will follow that case forever. And if you get a finding, like it or not, they think they're doing a good job or not, if you get one of these JPs that says, I don't find that police officer credible, because they don't like their attitude or anything else, and they haven't gotten to see the body cam that's going to take at least a couple of days to produce, to go, oh, wow, there it is. I see it. Happened just like they said it happened. You got personal attitudes, and you're going to get a finding. I know Mitch is waiting to ask me questions, and I would say, Mitch, you and I, when we do findings of fact, we do it at the end of trial. We never do it at the beginning of trial. We do it at the end of trial, and that's because we don't ask the judges to make a finding of fact until they have seen all of the evidence. And so asking our magistrates to do this in the first 24 hours is going to cause problems with your prosecution. And so I am up here with my prosecutor hat on for this one, and I'm telling you it's going to cause problems.
Mr.
Representative
Speaker.
Little,
Mr.
I
Little,
see
for
you
what
there.
purpose?
What can I do for you?
So will the lady yield for
Will
questions?
lady yield for questions?
Always.
Lady yields.
Happy to.
I didn't want to interrupt you because I don't like being interrupted either.
I appreciate
Representative Johnson, can you tell the body, why do you suppose that when we heard this bill in committee, we did not hear from a single prosecutor or law enforcement official that they had a problem with this bill?
I think it's hard to come up and politically say, hey, I tell you, I have heard, and the reason that I've heard is because I have gone to some of these intake divisions to say, show me your process, because I want to know how it works, and I have talked with the people on the ground, and here's what I know from them. If you do findings of fact, and Rep. Gomez asked the same question, who's going to write this up? You're going to have to create staff or somebody else to write it up. And I think you're actually going to put a burden, for example, in your bigger counties that actually have an intake division, I think you're going to push this burden to the DAs. They are now going to have to be trying to figure out. And the problem is, in your smaller counties where you don't have that, you're not going to have anybody to do it. So I would also say, is it one of those things where you think, boy, I'd like to find no PC. God, that is one big pain in the rear end.
Sounds like you're concerned about growing government, Representative Johnson. Is that the concern?
I am concerned about continuing to gum up an already complicated and busy system for political purposes. It's actually going to hurt people from being safe. I care very much about not only the right of the accused to have their due process, but I do care about the victims. And if we put in place a mechanism that in the first 24 hours sets the victim's opportunity to have the true evidence in the case be heard, because we did a political gotcha to Harris County and their magistrates because we're mad, all of y'all are going to suffer from that.
Representative Johnson, are there magistrates in Harris County now who are releasing potential criminals on lack of probable cause without findings today?
I am sure there are folks that are being found no PC in our court system.
Why
And
don't-
i-
then
is
why
that
don't-
written?
I'm sorry.
No, I'm with you, which is, I know people want to hold people accountable. I get it. So hold people accountable. Elections hold people accountable. Hold people accountable. I honestly, Representative Mitchell, or excuse me, Mitch Little, I made you Mitchell, I apologize.
okay. People do that a lot.
Representative Little, and this is why I say, and I appreciate your input on this, we don't submit findings of fact until the end of a trial when we heard everything. And that's what bothers me. When it says, do a written document of findings, like findings of findings, I don't even know where we find findings of findings. We're making up a term that in reality is going to become findings of fact.
The Representative Johnson, my belief is, and I think you'll agree with me, that today in Harris County, there are people who are being charged with crimes released based on a lack of probable cause. It's happening today. We just don't know why.
We do know why, and you can follow that case. And here's another frustrating thing. If you see that somebody is found with no probable cause, then follow that case. Did the DA dismiss the case because there truly was no probable cause? Or did the DA come back and refile the case or take it to the grand jury? Was it because the DA needed room and time to collect more evidence? And that's my only concern. Yes, you have no PC and it's done and it's over and the case is done. But occasionally, you have a mistake on no PC that needs to be corrected by the state. I don't know why you're asking for a judicial finding from a magistrate when the rest of the trial has to proceed before an elected district court judge who's going to hear the case and then make findings. I just don't like this findings of findings thing because I think it's not a pure definition and it's in essence going to become facts. It's in essence going to become witness credibility, and that's going to taint the rest of the trial.
I don't think that that's right, Representative Johnson. I think the answer is we have people who are potential criminals being released onto the streets of Harris County and other counties on a finding of lack of probable cause. We just don't know why. And the point of the bill, the point of Representative Smithy's bill, is to make them tell us why. Put it on paper. And it happens in civil cases and family law cases every day as a matter of course without incident.
And I would say, as a prosecutor who is standing there, and I'm reading out a DWI, and it's a question of whether or not they're operating the vehicle, the judge is always going to come back to me and say, wait a minute, what are the facts around whether or not it's operating a vehicle? And I'm either going to have them or not. We all in the room know what we're lacking.
Ladies' time has expired.
Thank you.
Thank you.
The chair recognizes Ms. Gomez on the bill.
Thank you, Mr. Speaker, members. I want to bring us back down to a very, very rudimentary level of, and not by a show of hands, but I'd ask how many of us here on this floor have participated in a magistration? A couple. It is a very unfortunate process that I hope we never ever find ourselves having to be in, or a family member, or a loved one, or a friend. In my instance, it's clients, my clients that I find. And I want everyone to remember, an arrest, a complaint is an accusation. It is not a finding. And this magistrate is the first individual, the first representative of the judiciary that the defendant is going to find themselves placed in front of to substantiate this accusation. So I know we keep saying criminals find themselves being released. We are talking about a person, an individual who has been accused of a crime, not yet found guilty. So this magistrate, who in Cameron County, I don't know how it works everywhere else in the state of Texas, but at least in Cameron County, and we've all been discussing this issue, a problem that we have across the state is our jails are overpacked, they're crowded, we're having problems, help us, help us. This bill isn't addressing that issue. This bill isn't solving that problem or creating uniformity across the state, as the author stated. This bill doesn't do that. So in Cameron County, we have magistrates who, in this case, are part-time county employees. 9 times out of 10, they are attorneys who are doing this service to the county on the side. They do it once in the morning and once in the evening, twice a day, and they are trying to do their job as judiciously and expeditiously as possible. We are now saying that this magistrate, this part-time magistrate, has to make a finding. And my question to you is, whom now are we placing the burden of proof? Whose job, whose responsibility is it to draft this finding? Because at the end of the day, if you've never seen a court order or a magistrate finding, it's a piece of paper that says, I, so-and-so magistrate on this day find, boom, probable cause. It is a form that they stamp very quickly and move on to the next defendant with. We are now saying magistrates no longer have to rubber stamp this form. They have to write out, but only in the instance that they do not find probable cause. And let me be clear, ladies and gentlemen, magistrates, when they look for probable cause, they're not looking at the history of the defendant. They're looking at the 4 corners of the police document, of the complaint, of the police report, the 4 corners of the report. That's what they're reading, the report that is presented to them, to see if there was probable cause or not. And now, if after doing that, they do not find probable cause, they have to create another document. And my question to you is, when are they supposed to comply with this unfunded mandate? I can guarantee you right now, the judge is going to turn to the prosecutor and say, hey, do you want to write it? And the prosecutor is going to say, that's not my job, that's not my burden.
Mr. Canales,
Does the gentlelady yield for
the lady
questions?
yield for questions.
Yes, Representative
lady
Canales.
Does anybody right now make findings of fact of no probable cause?
Absolutely not. And let me tell you why. Because you and I'm certain, have done this on a multitude of occasions.
How much would that help a criminal defendant if the judge is in a rush or 24 hours, if you're defending somebody and you get a finding of no probable cause, how big of a push for that defendant is it to walk?
Oh my, take it to the bank. I'm going to get a certified copy of that document, and if the DA chooses to bring this later, I'm going to subpoena that judge as a fact witness in court to testify why they signed this certified document saying there's no probable cause. You have destroyed
this body
the
should
state's
take
case.
This body should take note that I'm a criminal defense attorney, and Ann Johnson is a career prosecutor. She's telling us this is bad because it's going to put us in a pickle. And as a criminal defense attorney, I'm telling you, this is great for defendants.
Yes, it is.
This is great for defendants.
Yes,
this
it is.
is absolutely turning it on its head.
I completely agree with you. Members, this is going to be one of those cases where we look back and say, forgive them, they know not what they do.
Mr. Smithy to close.
Thank you, Mr. Speaker. Members, I know we are killing bills as we speak. Let me just say this. This is not my bill. It's not some idea that I had. It's part of a comprehensive plan that the governor, in collaboration with the Senate and the House, have developed to try to fix what Governor Abbott has described as a broken bail system in Texas. This bill doesn't deal directly with bail, but it's part of the problem. It's to provide accountability and transparency to the process, and those are never bad things. And so we go back to our hearing that we had on this in committee. We had district attorney after district attorney testify in favor of this bill over and over and over. We had the Austin Police Officers Association, the Houston Police Officers Association. We had constables, and this hearing actually was conducted about 11 o'clock at night.
Mr. Speaker,
Mr. Hunter, for what purpose?
will the gentleman answer some
The
questions?
gentleman yield for questions.
Always, yes.
The
Now,
gentleman.
Mr. Smithy, the coastal delegation saw you get up to the mic for over an hour of titillating lawyer discussion. Does this bill have anything to do with TWIA?
No.
Does it have anything to do with oysters or shrimp?
Not that I know
Then,
of.
as coastal advice, you might want to move passage.
All right, thank you, Mr. Let me just say, this is the result of a long process to try to fix what is a very important problem facing Texas today. I would move passage.
The question occurs on passage to engrossment of House Bill 75. This is a record vote. The clerk will ring the bell. Show Mr. Smithy voting aye. Show Mr. Cook voting aye. Show Mrs. Weiner voting nay. Show Mr. McQueenie voting aye. You've all voted. There being 87 ayes, 41 nays, House Bill 75 is passed to engrossment. The chair announces the signing of the following in the presence of the House.
SB number 2122, SB number 2269, SB number 2306, SB number 2371, SB number 2411,